we can start.
Good morning, everyone, and welcome to the launch event at Swiss Cyber Expo. I'm Riley Hill, the Marketing and Events Manager, and would like to thank all of you that have joined us. Today's agenda consists of 5 sessions of keynote presentations and panel discussion with top cybersecurity experts from Switzerland and the US. And they'll share their knowledge and expertise on various cybersecurity topics. At the end of each session, we will offer a live Q&A where you can ask your questions. And now I would like to hand over to Samir Aliyev, the founder and CEO of Swiss Cyber Forum.
Hello, everyone, and welcome to Swiss Cyber Forum, also our new platform, Swiss Cyber Expo. Now there are hundreds of people online at the moment on the platform, and you can enjoy our entire day sessions. Today, we will start with Evelina Georgieva and Theodora Dragan. It's our first live event, and I am so pleased to introduce it to our platform, to our attendees. Theodora Dragan is a data protection officer and legal counsel at CyberPeace Institute from Geneva. She's joining us from Geneva, and we have Evelina Georgieva. She's an entrepreneur. She is a co-founder of Pryv, or SA from Lausanne. Then we will talk about safeguarding digital data in Switzerland, and we will see the perspective from Swiss data protection law, GDPR, and the regulations from United States. It is your stage, ladies, and I'm so pleased to have you. Thank you very much for your time, and let's start for the presentation. Welcome to our Swiss Cyber Expo.
Hello, thank you very much for the introduction. Just to confirm, if you see the screen.
Yes, we see the screen.
I see it too. I'm very happy that we can see it.
So I'll let Theodora start and open the presentation from this morning, and I'll join her after.
So thank you very much, everyone, for joining us today for this session. What we will discuss is the topic of safeguarding digital data in the context of international data protection legislation. So we will be looking at 3 different approaches: the EU approach, the Swiss approach, and the approach that is followed in California, which is an example of the US approach. So we will be looking at the differences between those approaches, and also how to make sure that you can comply with all of them, and in how far they differ from each other. So to introduce myself quickly, I am the Data Protection Officer at the CyberPeace Institute. The Institute is a nonprofit organization based in Geneva, independent of any political ideology, economic interest, or religion. So we are, our task is to ensure and enforce accountability across the cyberspace to ensure peace in the digital space. So we are organized around 4 different pillars. One is assistance, so we provide assistance to victims of cyber attacks. We also provide the second pillar, which is analysis, where we analyze cyber attacks to understand why they happen and how they can be prevented. We work on advancement, which is our 3rd pillar, to advance the laws around cyber topics. And we also work on foresight and capacity building. That means that we forecast and investigate opportunities, risks, and threats associated with emerging or disrupting technologies. My role is to define the privacy requirements for the data that is used across these 4 pillars, and especially when it comes to data of cyber attack victims who are located all over the world, who can be impacted in different ways by different cyber attacks. So there's a lot of cross-border elements to my job. This is a bit about the Institute and about myself, and I will let Evelina introduce herself.
Thank you, Theodora, and thank you, Samir, for the intro as well. I'm one of the co-founders of the Swiss-based company Pryv, which was founded in 2012, here based in Lausanne. We're a software company which developed the software that helps organizations that are dealing with sensitive and personal data to achieve compliance and to manage this sensitive data rightfully with respect to different data protection regulations. We work within the healthcare industry, insurances, and some other like smart cities and fintech, where these companies are building new generation of platforms that are collecting and processing sensitive personal information, and they're under different protections in Switzerland, in Europe, and globally. Today, I'll be sharing more practical experience, working with them and sharing some of the practices and let's say the solutions that have been put in place to help them safeguard data. So my contribution today will be more from practical example sharings. I think that the subject that we have today, it's very interesting, it's very relevant, and it's also a big topic. So together with Theodora, we're going to try to summarize the essentials. And to start with, based on our practice and experience, there is a big misunderstanding, which is surprising for us coming from the industry, but it's still a fact that many businesses are not yet making the distinguish between what is privacy and what is security. And very often they're thinking that security covers privacy, privacy covers security. And if you put some security measurement, you're going to be privacy compliant, and the other way around. So to start with, we would like to share with you some of the similarities and differences between security and privacy. So I'll let Theodora open the subject.
Great. Can we move to the next slide? Great, thank you. So when we talk about privacy and we talk about security, like Evelina was saying, there's a big misunderstanding, and especially we've seen that at the C-suite. So when it comes to executives that want to have more of an overview, but are not directly involved in the specific setting up of the privacy measures or the security measures, there's this misunderstanding whereby there is the belief that if you comply with GDPR, you're fine from a security perspective, or that if you adopt a security standard like the ISO 27001, that 27001, that in that situation, you're also okay for compliance with GDPR or with other privacy legislation. Now, the reason I was thinking about this, what is the reason that we have such difficulty and we see such difficulty differentiating between privacy and security? And it's probably to do with the fact that we are talking about an intangible asset, which is the data in a digital form. So when we think of a real asset, and I find that it always helps to give examples, and to give examples that are practical. So when we think of a real valuable asset, like let's say a diamond or an expensive watch, you think of that asset and you want to protect that asset, you put it in a safe. That would be the equivalent of security. And the code that you put on that safe is the equivalent of the level of security that you think is adequate to protect your diamond. However, let's say the privacy standard would be comparable to whether that diamond was sourced ethically, whether there is an accountability around that diamond, and whether certain regulations about how that diamond is made and measured are respected. So it doesn't mean that just because your diamond is in a safe that it was ethically sourced. Just like that, just because your data is in a secure environment doesn't mean that the requirements around data collection were respected. So you can be in a situation where you're perfectly compliant with the GDPR, but your data is actually exposed from a security perspective. Or you can be in a situation where your data is super safe, but actually when you open that safe, what you find in there is not what you expected in terms of the regulations being in order. So it's really important to think about that and about what safeguarding data actually means, because we need to think of it as a yin and yang. So both privacy and security must come together for data to be properly and truly safeguarded. And one is not enough without the other. Evelina, I think you had some points that you wanted to make about the ISO standards that could be relevant for the participants today.
Yes, concerning this subject, what we're seeing very often in our practice is that many organizations that went already through ISO 27001 process consider, for example, that they're GDPR compliant, which is not correct. And Theodora rightly mentioned what are the differences, and it lies in the basic of the General Data Protection Act in Europe and in many others across the world. It is true that recently there was also the introduction of ISO 27701, which is introducing an additional framework for complying with the data protection requirements and making it easier for organizations to make this gap between security and privacy, and be easier for them to comply with both. Still, it's not covering fully, and it's important for organizations to keep in mind that even if they're having the ISO 27001, they have to be very careful and look at the countries where they're operating and what are the particular data protection act that apply in these countries, and what measurements should be put in place, considering all the consent, how the data was collected, what were the purposes for this collection, to be able to delete the data, to prove where the data is physically stored, and many other aspects that I'm sure that most of you are already aware. And because I already introduced GDPR and it's one of the main subjects of the discussion today, I would like to move to the next part of our presentation, which is highlighting the similarities around safeguarding data from the perspective of one of the most popular regulations. And please, Theodora.
So yes, thank you for that. When we were preparing this presentation, we thought, okay, where should we start? How should we introduce the topic in these different countries? We know that the approach in practice is very different, but actually when we look at the laws and the specific articles in the different laws, we see that they all flow from a very common basis. So when we look at the words used, we see appropriate technical and organizational measures under the GDPR. We see adequate technical and organizational measures under the revised Swiss Data Protection Act. And then we also see reasonable procedures and practices that are appropriate under the California Act. So the wording is similar. Also, the purpose of adopting such measures is similar. So it's expressed as ensuring a level of security, ensuring security, or implementing and maintaining security, which is more or less the same thing. And also we see that across the different legislations, there is this concept of being appropriate to the risk or being appropriate to the nature of the information, which again is similar in terms of what the legislation is trying to achieve. So when we look at these, it's reasonable to expect that each different company in those three jurisdictions would have very similar things to do in order to demonstrate that they are safeguarding data. So if you just look at the law, you would be tempted to believe that taking one step for one legislation will be enough and will cover you for another legislation as well, because you see the words are quite similar. However, the approach in practice is very different, because the law is not just limited to what is written in, the requirements are not limited to what is written in a piece of law, but there are also recommendations, guidelines, suggestions, and other pieces of, let's say, secondary law, where including also decisions of the courts. So that means that in practice, the approach is very different. And we will look at how this approach is different and how the different data protection authorities expect different things from companies located in different places. So I think we can move to the next slide. Thank you. Like I was saying, there's no one-size-fits-all approach. And to give more indication and more support to people looking to implement the appropriate security measures, each jurisdiction has published some guidelines. So in the EU, these would be the guidelines on data protection by design and by default. These actually tell you how you should think about the security measures that you adopt and how you should determine whether they are in line with the risk and with the nature and context of the data processing. I believe the presentation will be shared with all of you after the webinar, so you will be able to click on the links and you'll be able to access these documents So in the EU, like I was saying, there are these guidelines. There are a lot more guidelines issued by the European Data Protection Board. And in all of the different ones, even though some are on other topics, there are still recommendations around security. So it's not even these ones are the only source of information, but they are still a valid and important source of information for the EU perimeter, let's say. In Switzerland, there is a guide for technical and organizational measures, which is available at the link there. That guide is from 2015. So we see that, 2015 was already a few years ago. And when we look at security and privacy, there are such quick advancements that what is in that guide may not be the state of the art anymore. But it's still a good place to start when you're looking to implement security measures for your data if you're based in Switzerland, or if you're processing data of people who are based in Switzerland, or if you have data centers in Switzerland. Finally, when it comes to the US and the California situation, in the 2016 data breach report, which was actually published by the then Advocate General Kamala Harris, and which is available at the link, there are 20 controls known as the critical security controls, which are taken to constitute a minimum level of information security that all organizations should meet. And then there are different levels for different organizations, depending on the size and depending on what specifically each organization does with that data. Now, I've selected some keywords from all these different legislations, and these keywords appear throughout the various guidelines. So encryption, we see pseudonymization, anonymization, malware scans, penetration tests, the use of strong passwords, and the use of passphrase is actually something that is recently more and more recommended, more than just a password, which we think of when we think back when we started to have our first accounts, the password was really just one word that could be the name of your dog. Now we know this is no longer the case, and now it's actually suggested that you have a passphrase, like, I don't know, for example, you can have I like pizza with mozzarella, and that would be your passphrase, and then replacing some of the letters with numbers or adding some characters in that passphrase. So that is the recommended approach now. But you can see that things evolve with time, and both privacy and security are areas where what was okay yesterday and what was considered sufficient yesterday may no longer be applicable today. So all these approaches are always to be considered as a starting point, but the biggest challenge for data protection professionals is to make sure that they are constantly updated on what is the newest trend, what is the newest issue, what is the newest challenge, and how to address that. To finish on the slide, so another keyword that I've seen in all the different approaches across jurisdictions is about access rights. So giving individuals the right to access their data. So that also means being able to identify an individual's data within the whole data set that you actually process as a company. So being able to select whose data belongs to whom, and then giving the individual access to that. Carrying out risk assessments and also vendor assessments. These are also topics that are common throughout the different legislations. So definitely we can say that if you look at these keywords and you implement you start implementing these recommended measures, you could be already at a good place, both in the EU, in Switzerland, and also in the US. However, the way you do it, and especially the way you document it, will be very different. And each data protection authority in the different countries, thank you, will want to see something else. And that is the biggest challenge, because it's almost like thinking of different languages that the authorities speak. And even though you're using something very similar, you still should put it in the right way for the authority, so that if you do have an inspection or an investigation or a request from an authority, you can prove it in the way that they have defined those controls, and you can display and show that. So when we look at the EU approach, first of all, this approach is applicable to all controllers, including small businesses and multinational companies. So it's the most overarching approach. For example, the California Act does not apply to charities or nonprofits, which I personally think is a mistake, and it's a lost opportunity, also because many times nonprofits actually process a lot of personal data, they collect a lot of data, and they also receive, so they are contacted by people who are in need of assistance, who provide them with a lot of data. And most of the times these people are for some reason or another, they're in a vulnerable situation. So, you know, I think that the EU approach is a bit more solid because it does apply to all different types of organizations, not just for-profit organizations. Now, under the EU approach, being appropriate, so taking the appropriate measures, means that the measures and safeguards have to be suited to achieve the purpose, which doesn't help us that much. But then we read that they must implement the data protection principles effectively. Again, this is all nice to read, and it kind of makes sense when you read it. And I think everyone can agree that, you know, it makes sense. It's a sound approach. However, when you look in practice and you think, okay, so where do I start? The elements that you have to take into account to establish effectiveness are these 4 elements that are presented on the slide. So state of the art, when it comes to the state of the art, you have to think about the continuing development of the technology, but also of the necessary safeguards. So also of how easy it is to breach or hack a certain technology. With time, that becomes easier and easier. And when you have a newer technology, maybe that technology is considered safer at first, but then with time, there are more and more backdoors that can expose the data contained in that technology. Then when it comes to cost of implementation, this is the EU makes a big point out of saying you can take that into account when you select between different providers, for example, but it's not an excuse for not adopting a measure, the fact that you don't have the budget. So it should be in line with the budget of every company. So obviously, a small company that has a budget of maybe, I don't know, 100,000 for everything cannot really dedicate 99,000 to privacy and security, because obviously privacy and security still have to serve the purpose of the business. So they cannot be, and they are not the core business of many companies. So they have to follow into the footsteps of the main business, because otherwise, without that business going, there is no privacy and security to apply to anything.
That's one practical point here, Theodora, sorry, because I found it very relevant with many of the organizations that were in contact and talk to us. It's completely true to say that in many cases, no matter what is the size of the organization, being small or big, in the budgets, it's not foreseen to have enough money or resources that are allocated towards privacy and security. And we consider this being a massive and big mistake, because once the product is ready to be launched on the market, sooner or later it hits the wall, and all the investments and efforts that have been put in place are worth nothing, because rebuilding everything from the scratch when the product is already on the market, it's much more expensive. There is an enormous time that is already lost. And this is one of the main reasons, not even to mention the first one, why today we see with the technology development so many projects and products failing instead of achieving their goal. So my recommendation, based on our experience working with so many organizations, it's not to underestimate the budget that goes towards privacy and security, and most importantly, to think in advance for investing in this, because security and privacy can be really a competitive advantage. Another big mistake that we see from our practice is that it is in the roadmap of the product development, but many of the project or product leads are saying, yeah, that's fine, we know that we should do it, but let's do it later on when we already have everything put in place. Very often we're making the comparison, and I like, as Theodora, giving a few examples with buildings and the foundation, really like the plumbing of the product. Once you already have the entire building built, it's extremely difficult to change the plumbing and the foundation. So really we encourage any organization that is serious in collecting and using, processing personal sensitive data to think timely from day one and to dedicate the resources and the budgets that are needed to ensure privacy and compliance, no matter of the geographical reach that they're aiming. Thank you, Theodora, for having this example put in place, and please continue.
Absolutely, I fully agree with you. Actually, I think it's a good example, and I think many times it's not taken into account enough. And I've seen throughout my career, I've seen many projects that were brought to for a legal review or privacy review later than they should have been brought, and some have had to be canceled because the entire premise of the project was basically not privacy compliant for that specific jurisdiction. And obviously there's a lot of disappointment when resources have been invested, but also not just financial resources, but also the emotional investment of the people working on the team. So really the recommendation for me as well follows that of Evelina. So save yourselves the resources, the effort, and also the emotional investment of working on a project before you know if you can actually implement it or not. Because if you find out that to implement it, you have to, for example, collect a consent, and that consent has to be documented, but you did not envisage, or in that certain circumstance, it's impossible for you to collect a consent and to keep it and to keep a documented evidence of it, then obviously you will be in a situation where you cannot go ahead with it and still be compliant. So also there are some projects that are maybe a bit ahead of their time, so it's hard to understand exactly what and how, what kind of security measures to apply to them. So this brings me to the third point here, the nature, scope, context, and purpose of processing. Again, these are mentioned throughout the GDPR a number of times. And when I was reading the guidance on how to interpret these items, I will actually read it out to you because I think it's important to respect the wording that is followed by the European Data Protection Board. So the concept of nature can be understood as the inherent characteristics of the processing. So you can see that nature has to do with what you're actually processing for, whereas the scope refers to the size and range of the processing. So here we talk about volume of data, we talk about frequency of data, we talk about how much data and how quickly you collect and how quickly it is updated. When it comes to context, this relates to the circumstances of the processing. And the most important thing to remember about the context is that the context may influence the expectations of the data subject. So when a data subject has certain expectations, that context can be more prone for a data collection. When the data subject doesn't have those expectations, there may be an issue about transparency, or there may be an issue about the understanding of the data subject. And finally, the purpose of processing is probably the simplest concept here. So it's about really what you're trying to achieve with processing that data. Finally, when it comes to risks, there is a very useful guideline, which is actually on DPIAs, on data protection impact assessments, where risk is discussed extensively. And there's a list of 9 factors that can indicate a higher risk. This has to do with whether the data is sensitive or not, whether the people whose data is processed are vulnerable or not. So basically what the EU is doing is it's giving a number of elements that they say help establish effectiveness of the safeguards, and then you have to take into account those elements and indicate ideally what it is that you are doing on the basis of those elements to select the right data protection and security measures for the data that you have. So obviously these are very European concepts. So if you take this approach and you present it to a regulator in California, it will be, you might have some similarities, but the regulator in California may not really understand why you're taking that specific approach. So let's look at Switzerland now. In Switzerland, as I was saying, there's a list of technical and organizational measures that are recommended, and that link was on the previous slide. So you will be able to access it. In Switzerland, there is the approach based on 4 points. So on data access, data lifecycle, data exchange, and the right to information. So around these 4 points, there are indications and suggestions. But the most important aspect of the Swiss approach is actually in this table, because this table presents the nature of the personal data and in accordance with the risk level, and that must relate to the information classification policy. And it's actually one of the most, I'd say one of the most useful approaches that I have found in all the different documents, because it really helps to understand what is the matrix. So what does it mean if I have a certain type of data and a certain type of risk, and what do I have to do with that data as a result? So how do I have to protect it? What are the measures that are considered appropriate or adequate? So again, here you may have these different words that describe the data and the different type of risk, but maybe that risk categorization is not the same in the EU or in California. So again, if you're taking the Swiss approach, so let's say you're a business based in Switzerland or you're processing data of Swiss people, then it's useful to use this matrix and to use the 4 focal points for data to build your privacy and security safeguard strategy. Evelina, would you like to add something on this topic?
I think the information that you shared, it's enough. What I'd only add is because we're working with businesses that are having a global vision, one of the big issues that they have is the mindset of how to build these systems being globally compliant with the different regulations. So again, what we're suggesting and advising them at very early stage is to think globally, not locally, to make this type of matrix and analysis, which country comes with what exact requirement. You mentioned in the previous slide, for example, with the processing of the data, and you mentioned the consent, which are extremely important subjects. So what we encourage them is when they're building the infrastructures of this data platform, to think globally and to put focus on some very important contexts like the consent, the data structure, and the auditability. So at any given point of time, they can rely on the purpose of the collection of this data to be able to provide proof that the consent has been executed rightfully, and also to be able to map the data in accordance to the level of sensitivity it has, exactly as you mentioned on the Swiss one. So there is no like a very specific or a secret source of how to make one organization being both security and privacy compliant on a global scale, but by putting in mind this very basic mindset thinking will greatly help them to achieve this purpose. And the third one that I would like to share today with you, and this part of the presentation, it's the California approach, which I also found very interesting. I'll let also Theodora present it and we'll comment further.
So for the California approach, there is a list of SIS controls, which is available at the link that I posted on the slide. So you'll be able to download them. There are 20 controls. So I thought there are quite a few to go through it today as only part of this presentation. Maybe with the Swiss Cyber Forum, we can organize a separate event and discuss just that approach, because it's enough material in itself for a workshop. But
exactly.
But the approach here is that there are different controls for different levels of companies. So it's something that is useful, although, like I was saying, they are not, some organizations like nonprofits do not really come in scope of this approach. But for other organizations, there are, for example, small organizations, then you have small and medium-sized enterprises, and then you have the big enterprises. So for the smaller ones, you just need to adopt the first group of controls. For the second one, you have an additional layer, and for the third level, you need to adopt all 3 of them. So it's not, they are not different, they are just building one on the other. Also, when you go to the link that is posted there, you will be able to download not just the PDF that explains what the controls are, but also a very useful Excel file where all the controls are listed, and you're able to use that to kind of check off and say, we have this, we have this, we have this. So this can be useful, for example, if you have already started with a compliance process in Europe or in Switzerland, and you're now approaching, let's say, the US market, and you want to make sure that you're compliant, that framework is actually super useful for you to go through it and check it, and also put your information about your privacy and security program into that framework, and then be able to demonstrate your compliance in the way that the US authorities would expect to see that. Would you like to add something, Evelina, or?
As you said, it's a subject on its own, and I'm just looking at the time, and I know that we have very interesting further content to share. So I suggest that we discuss further a separate workshop on this one for those who are interested, particularly in the California approach, because there is much to be said there. So we save the time to share with the audience what we have prepared for today. Okay, so let's go to the next slide then. So this one is really a very practical slide where we ask ourselves, where do we start? We know that if we're talking about a small company that is based in one country only and processes data of people who are based in that country only and uses service providers in that country only, then obviously it's a very simple solution, and it's a very simple situation, because you just need to look at one jurisdiction, you need to understand the law in that jurisdiction, the recommendations, and then you start working on that. You have your little framework and you're compliant, and that's it. However, in today's world, especially the world as it was impacted by the pandemic, with all the sales becoming online, even for small businesses that maybe were selling, in their small corner shops, they are also selling online now. And obviously, let's say this Zoom boom has kind of opened the world to being more international, more online, and to use more data as a result, because obviously when you want to organize a webinar, or you want to start doing online sales, or you want to interact with your customers who are based abroad, obviously it will be very hard to find a company nowadays that only processes local data. Because why limit yourself, and why limit your company and the potential of your company to only one small area? So having said that, obviously the international challenge is really the biggest challenge for most companies. And I remember back in 2018, when I attended a seminar organized by the Italian Data Protection Authority, this image of Edward Munch was, of the scream, was used in relation to the DPO's situation, joining a company as a DPO in 2018, where the world was changing very fast in terms of privacy, and you really didn't know where to start. So the tips on this slide are really to help you go from this to kind of smiling and taking it easy and really working towards your compliance. So the first step is to understand where your risk lies. And this is the most important step, because you don't want to work on fixing your door and putting more locks on your door when basically all your windows are open, or even worse, you have no windows, you just have holes in the walls that would allow people to come in. So where is your risk? What is the type of data that you process? What is the nature of the processing, and what are the categories of data subjects? These are really the first things I would be looking at if I started a compliance process with a company tomorrow. These are the first things I would want to know. If you collect a lot of data. Yes. One practical example here, also coming from our side, because you're using an example that we do often as well with locking the door and the windows. And the nature of processing of the data, which we're going to touch point in a few slides in a few minutes. Very often the right approach and tip that we see, we advise and we see working very efficiently, it's around the consent of the person, where privacy it's having a crucial role, not in the sense that data is logged, but rather explaining to the data subject and the one who owns the data very clearly for what purposes the data is collected and how it's going to be used, and going towards the sense of dynamic consent, where you keep a bridge and relationship with the user, so you can bring this confidence then in this case, it's not really locking the data in this kind of safes, but giving the opportunity of a very transparent exchange with the owner of the data, so they can give you authorization of entering the room rather than only closing the room. So I'll be feeling confident if you enter the room when I know that it was me letting you in and what is the purpose for your visit. So this is very interesting approach of understanding where the risk lies, and if a risk is identified at a later stage, to have the practical technology infrastructure, not to have to rebuild everything, but to be able to adapt it on a lively basis without losing what has been already built. So this is when we're speaking of continuous data lifecycle improvements over managing and collecting personal data. Thank you, Theodora.
Yeah, I think that's an amazing point, and definitely what I have noticed also working with different companies in my career so far is that whenever there was a situation where there was transparency about the processing and also transparency about the accountability and the measures taken by a company, people were more inclined to trust that company with their data. And the company itself didn't find itself in a position where it had to kind of beg the customer or trick the customer into accepting something, but actually the customer would be willing to provide some data just because they understood what was the purpose of it, and they understood how that could give them a better service or how that could help them have a better experience. So they wanted to share that data. So that's a very important point. Thank you. So moving on from understanding where the risk lies, you then have to understand where the threats lie. So where the threats lie will depend a lot on what sector you operate in. If you operate in the consumer-facing sector, if you're providing services, if you're providing essential infrastructure, and also what are the consequences of a breach. So a recent example was a ransomware cyber attack on the Colonial Pipeline in the US, which had as a result the fact that the petrol stations in some areas of the US are running out of gasoline because of that cyber attack on the pipeline. So if you operate in an area that provides essential services, so it could also be you operate in an area of logistics, shipping, obviously the consequences of a breach are not just affecting you as a business and not even just your direct customers, that could be B2B or B2C, but they could potentially affect a lot more people than you. So understand how, what consequences the breach could have can help you understand, okay, what are the main threats? Who would have an interest in trying to hack my business, or who would have an interest in trying to conduct a cyber attack? So this goes from understanding what the trends are within cyber attacks and understanding what is happening, what malware attacks are happening at the moment, where the malicious actors are and what they're looking for. So obviously it also has to do with reputation. We all know that when we talk about risk and we talk about personal data, we talk about reputation. But really, what I encourage you to do is to look at your threats, not just as, oh, the threat of getting a sanction, like, oh, I'm going to get a sanction, that is my biggest threat. That's really, in most cases, that is not your biggest threat. So really try to understand that. So once you understand where your risk lies and what the main threat is, in the example of a house, you know, your risk lies maybe in the room where you have your beautiful diamond, and the threat is that someone can come and take that, then you need to address your highest vulnerabilities first. So protecting the important data assets is the first step. And also a super important step is to train your employees. Employee negligence is still today the most common cause of data breaches, and it's more common than malware or software failure. And it's a very preferred phrase within cybersecurity circles to say that you're only as strong as your weakest link, but it's true. So employees, especially new joiners or employees who don't have a lot of experience within cybersecurity, employees who work with, let's say, who work in the sector or who don't really understand because they don't have the awareness. It is in your interest as a business to make sure that your employees are trained, even if that is a cost upfront, but it really helps you make sure that your data is safe. Because a lot of the times the situations of data breach happen inside the company, and it can be someone who by mistake or because they're not careful, because they're a bit negligent, they send an Excel file with information of customers to a service provider. or they send the information of one customer to another, or they receive information about some customers and then they accidentally share that online, or the cases are really endless. And let's say the highest vulnerability really is the employee who's not properly trained and who doesn't know how to use the systems. Because if you have the best systems in place and you have the right access controls and the system is secure, but then within that system, every employee still has some rights in order for them to perform their job. And the reason why they have those rights may be a specific one, but if they don't know, or if they then let's say because it's easier, they end up using the password of one of their colleagues because they forget their own password, so they just need to access that system quickly. Those things can really lead to big breaches. So then my suggestion overall is to, when you look at where to start, to first understand the risk, understand the threats, and then start by addressing the highest vulnerabilities first, and then close the gap from outside towards the inside, so that your weakest link can become stronger, and therefore you can become stronger as a business.
Maybe just one point to add on the subject for train your employees, a bit from a different angle and perspective, but still very relevant to consider. Very often we speak on the subject, are developers the new lawyers to be? We still see, we're seeing today a lot of experts that are coming from software engineering background and that are trained particularly about security. But as with Theodora, we started the presentation today between the interplay between privacy and security and yin and yang. They're still very tightly connected. And one of the biggest problems we see today, and the reason why many products again are failing and they're not achieving the purpose they have been designed for, is because the responsibility of building systems that are both security and privacy compliant are given in the hands of teams that are not expected to know all this information that today we're sharing with you, with Theodora. So our advice, again, based from our practice experience, is to invest enough resources into not changing the background of knowledge of your employees and making them lawyers to be, because we don't expect any lawyer to deploy any IT system or to build a data lake, but to invest enough resources in identifying what is the gap in the knowledge and onboarding either the right experts or resources, or looking at solutions that are available on the market that can support the development of your products, respecting security and privacy, so you can access and manage sensitive data rightfully.
That's a very good point. And one thing that I have also been recommending is that when you onboard new people, just because they don't really know the environment of the company, they may not know the right teams, they may need some time to get used to it. My recommendation is always to go for a staggered entry to the different IT systems and try to really allow the employees to have some time to understand the context, the environment, who they're supposed to share something with, what they're supposed to do. Because I think way too often someone is onboarded and expected to, be active and proactive and productive from day one, and like, we are giving you a 3-slide presentation on how the system works, and that's it, you're ready to go, please go and sell as much as possible. But the problem with that is that there's already a lot of pressure on someone who's joining a new company, and many times it is the newcomers, simply because they are not familiar yet with the systems, or they want to perform and demonstrate their own capabilities, and they're very keen. Not to say that employees have been around for a while are no longer keen, but they are more aware of the systems and also of the little, let's say, the little issues that a system can have. Or for example, oh, I should not really do this because it has this and this effect. But a new starter, a newcomer, might not know this from the first days. So it's really good to kind of slowly but surely introduce new systems to a new joiner, and to make sure that there's someone who is really available, and not just give them a file with this is how it works, please. Now you're expected to know how 20 systems work, and you're expected to have super complicated passwords, but we're not going to give you a password manager. So of course people will need to write those somewhere, and some people will write them on Post-its unless they have the right tools. So many times it is up to the company to really make sure that employees have the right tools to do their jobs in a certain way. Having said that, should we go to the next slide? I think we're nearing the end. Oh no, we still have.
I think we should speed up a little bit, maybe with the shorter content. So we covered the 2 other subjects that are left, and we wish to share. Maybe if we can do it in about 3 to 4 minutes, so we have about 5 minutes left for some Q&A that might be coming from the audience. It's a big subject, and there's so much content that we would like to share with Theodora, but maybe we have to summarize it a little bit faster.
Exactly, but I think this slide is really a useful slide that people can also use in their own time. So it contains some links about what happened around the safeguarding data and cross-border transfers. So everything started obviously with the Schrems decision of last summer. And as a result, there were some recommendations that you can access there. And there were also a few decisions of data protection authorities in relation to the measures that are considered sufficient for transferring data to the US. So safeguarding data does not refer only to the point of collection and to how you keep your data in your own house, but it's also about what happens when you send that data to someone else for processing. And obviously companies cannot be expected to do everything. They provide some services, but then they need to outsource some services to provide the services that are their core business. So many times, and especially in recent years, because of the tech scene in the US, there has been a lot of outsourcing from Europe and from Switzerland to US-based service providers because of a consideration of pricing, innovation, and general availability of a lot of tech services based abroad. The steps to take really used to be that you just sign the contractual clauses, you transfer the data, and that was considered enough, even in the absence of the privacy shield. However, we saw that this was not enough with the Schrems 2 case. So now there are some supplementary measures, and the examples are in the first link on this slide. So you need to take some more measures on top of the SCCs, and the different 3 data protection authorities have issued very recent decisions to say that, yes, we confirm you need to take these additional measures. Please start doing so. Don't think that there won't be fines, because there will be. So something to take into account, because up until last year, there were almost no decisions on data transfers, whereas now we are already seeing 3 in the course of a few months. So there are probably more to come. And another important resource that I recommend to all of you is the GDPR sanctions tracker, which is administered by a law firm, I think. And that really contains all of the sanctions that have been issued by the authorities, and you can go and have a look and understand what are the trends, what is being enforced right now. For example, now we can definitely see a trend on cross-border data transfer enforcement. So that was a quick overview of this topic.
As we promise some practical help in any subject that we're touch pointing today, this is the one that we'd like to share with you, with Theodora, and we call it trending decentralization of data in the scope of transferring cross-border, transferring data cross-border. There is much also to be said, but we're going to try to summarize it in 1-2 minutes. One of the solutions that practically works is looking at decentralizing the data. For example, the approach that we did take in Pryv, and it's embedded in our own software solution. It's allowing each user's data to be allocated in different physical locations, so the data does not leave the country on its own. So this is a very practical example that allows many organizations to build scalable solutions and to process data locally, instead of complying with different requirement how to do the cross-border transfer. It's important also to mention here something that is also trending, and it's very important. Normally, when a design of system it's foreseen in the beginning, it's not very clear what the processing of the data will be on a further stage, because there are many new opportunities that can come with the time. So there are 2 options: either the systems to be closed and the data not to be used at its full potential, or to build the systems that allow this data to be unfolded and used for further purposes. On one side, for example, today many systems are looking how to comply for the initial and primary usage of the data, but they still lack compliance because with the development of different AI, machine learning algorithms, and so on, in fact, they're applying a second layer of secondary usage of data for which they're not allowed for. And it makes it extremely difficult to comply at a later stage. So with the development of these new systems for using algorithms, machine learning techniques to process the data, we recommend this development of data platforms to look at solutions, how this can be done. And one of them, we already spoke about it, I'll just refer to the discussion we got a few minutes ago. It's leveraging on the consent and being able to request from the data owner and the data subject how this data can be further accessed and processed, and then, for example, transferred from one country to another. So when you have the consent of the person allowing you to do this transfer of the data, a bit like traveling with your suitcase, you know, it's in the diamond example of Theodora, when it's something like physical asset, you can really feel how easy it is to move it from one point to another. It's the same vision on the data. If you ask me if the data can be moved for whatever reason, or I would like to move the data because I'm changing myself countries and I would like my data to be treated under the same legal environment as I'm living in, I can do that if the systems are allowing me to do it. So please keep in mind and investigate what values will decentralization bring to your systems together with the power of consent and what Theodora already shared with you. Would you like to add anything more on this data transfer in a cross-border manner, Theodora?
No, I think this is really interesting, and the way you explain this, I think it's very helpful for the viewers of the webinar. And I think we're nearing the end of it, right? Yes, we are. So
I think so. So we didn't leave much time for questions. So there are only 3 minutes.
Actually, we have several questions. Maybe I can share the questions later on with you, but I would like to thank you for very, very interesting, insightful presentation. It was our pleasure really to host you. And Theodora, as you mentioned, maybe we can have another session for the specific for US-based regulations and see the difference between European data protection regulations and the American regulations that will help for many civil organizations that they transfer data from Switzerland to United States. And there are still a lot of open questions after the Schrems II decision and how to transfer data. Of course, today everyone's using the cloud, and it is a little bit uncertain for many companies if they have an access to their data from another part of the world. But that will be another topic, and that was really interesting start point for us today. I would like to thank you for both of you, also our audience, they are on the Swiss Cyber Expo live platform, also people here participating via direct Zoom link. What I would like to add that we have another session, another 4 interesting session, which we do at 11:30. We will talk about ethical hackers. Then we have another session, cyber diplomacy. Daniel Saylor from Bern, he will join us, and we have very interesting speaker, Anna Pulio. She will join us at 16:30, and she will talk current risk and how our lives will change after the pandemic and the cyber risk and the secure data risk after the pandemic. Then, end of the day, we will host a guest speaker, the keynote speaker from United States, Christoph Painter. He is ex-cybersecurity advisor to Barack Obama. He is top US-based cyber diplomat, and the topic will be cyber norms and the malicious state actors' activities and the measures that might be useful for many critical infrastructure responsible people. And please stay online. The platform will be online, and you can join anytime. Also, all the videos, all the recordings are available to the session also on the platform. We are looking forward to have another session. Thank you very much, Evelina and Theodora. Looking forward to host you again.
Thank you very much.
Thank you.
Everyone, a nice day.
Thank you. Stay safe.
Thank you.
Stay safe. Have a nice day. Bye-bye. Bye-bye.